Yes, self-control.
I think I've taken you to all the contemporaneous documents that I need to take you to. So if I could just take you to the judgment now, please, which, as you know, is in the core bundle, page 43, and take you to paragraph 214, page 80. I think I don't want to be too long this afternoon, but I think I need to address two separate points as I understand the case that's now being advanced. One is, did the judge actually find that a higher premium would have been charged by reason of the non-disclosed facts? And if, secondly, if she didn't actually find that, should she have found that? Which I think is limb 2 of the appeal.
Yes.
So starting with what she actually found, we can pick that up at paragraph 214, which I know you've looked at very carefully already. And as you know, it's the sentence beginning, doubtless the reason why the case was not really advanced on the basis of right or not right on the different terms is because, in my view, correctly accepted by Zurich, the only change which Mr. Penny would have made to the terms is not one which was related to the non-disclosed fact, but one which related to Zurich's earlier errors. And in my submission, that's a clear factual finding by her that the non-disclosed facts taken together, either individually or collectively, would not have caused any change in the premium.
So this is in paragraph
214.
Four, yeah.
Yes. It's the sentence beginning, doubtless, 5 lines down, at the end of the line.
Yes. Yes. Yeah. Yes.
And I referred earlier to the fact that this paragraph starts, I have included this consideration for completeness. And there was a question raised this morning about Zurich's acceptance. Was that an express acceptance or an implied acceptance? And we can see the judge's position on that in her judgment, which is at page 90 of the bundle, where she dealt with the Zurich's application for permission to appeal.
Yes.
Now, one can understand why, in her judgment, the judge didn't spend very long on this particular issue about premiums and so on, because that just wasn't the case that had been advanced by Zurich. But when Zurich said, well, we want permission to appeal, springboarding on your finding that there would have been an additional premium, she gave a fairly detailed judgment, which you have starting on page 91, when she rejected Zurich's application for permission to appeal.
Yes.
The first 6 paragraphs deal with ground 1, which was for which she refused permission and Lord Justice Phillips refused permission, so one can ignore those. But I do invite you in due course to read, if you haven't already, paragraphs 7 through to 20, because they do set out in detail more of the judge's reasoning than appears in the judgment, because it didn't need to appear in the judgment. And I'll just I don't know if you want to read that now.
Well, I haven't read it, and it might just be helpful if we spend a couple of minutes quietly to ourselves
I'll
reading.
shut up and leave you to read from paragraph 7 is probably the best place to begin.
Okay, thank you.
In my submission, that judgment on the permission for appeal makes it quite clear, if it's not already clear from the judgment. The judge's finding was that when one refers to X and Y, as my Lord Justice issue referred to before, there was an X but not a Y.
Yes.
And the passages I particularly rely on are in my firm conclusion based on the evaluation of the evidence was that if the risk had been properly underwritten and priced in previous years, Mr. Penny would have renewed without changing the terms. Paragraph 16, the full disclosure gives the occasion by which Mr. Penny gets the mistake. It does not cause the change. If one asks whether the correct disclosure would have caused the writing on different terms, there can only be one answer, which is no. Those passages are sufficient to take you to. So that's a clear indication that she was finding that the only reason there would have been any change was because Mr. Penny would have spotted what she wrongly thought was a mistake in the way the premium were calculated, and not because of any of the non-disclosed facts. And if one asks the question, well, if she had really thought that there were two causes of the increased premium that would have been charged, why would have she been going into the question about effective cause and but-for cause and so on? Because that just wouldn't have arisen, because she knew, and we accept, that had there been non-disclosure, which was an effective cause of a higher premium, that would have entitled the insurer to avoid.
She seems to have in mind a different mistake or series of mistakes than the one she was referring to in her judgment, because she seems to be referring to mistakes in valuing the risk in previous years rather than the mistake in the risk schedule in 2014.
Yes, I mean, she refers in her judgment to some historic mistakes at paragraphs 26 and 29. That was back in 2006 and 2007, when there was a failure to take into account the claims record. Paragraph 26 and 29 of the judgment. But those mistakes were, as it were, a matter of history by the time we get to 2013, and that was one of the reasons to take my lords and my lady to the passage from Mr. Penny's evidence where he says the premium in 2013 was correct. Whatever had happened in the past, you've got a clean slate in 2013. Now, I said that in this second judgment of the judges, paragraphs 1 to 6 dealt with the first round of appeal. In fact, it's paragraphs 3 to 4. Paragraph 2 is relevant. That just makes the point that this is a factual appeal. I'm sure I don't need to take this court to any authorities dealing with the restrictions on the ability to successfully appeal findings of fact, and it's common ground between the parties that inducement is a finding of fact. And I know that my Lord Justice Richards reviewed the authorities in the Asset Code case, which is one of the authorities in the bundle, which dealt with the question of, well, does the same test apply both in relation to, as it were, findings of primary fact or primary findings of fact as well as inferences? And the decision was yes, the same applies to both. So I think that deals with all I need to say about the question of whether or not the judge actually made a finding, unless there's anything I can help with further. So I turn to the second question. Well, ought the judge to have found that there should have been a higher premium? And standing back, one got to put this into context. Can it be said that the judge erred to the necessary degree in failing to find that a higher premium would have been charged when she had received 34 pages of written evidence from Mr. Penny and 200 pages of transcript evidence, oral evidence, in none of which at any point did he say he would have charged a higher premium? nor did any other witness say we would have charged a higher premium. Zurich nailed their colours to the mast, which was to say Mr. Penny would not have offered renewal terms at all. And it failed on that case. And having failed on that case, it can't now seek to say, well, actually, we want a second bite of the cherry and say, well, we think the judge should have, having rejected that evidence, in the absence of any fallback evidence, she should have found a higher premium would have been charged. It's common ground, there's no legal presumption of inducement. We accept that in an appropriate case, there can be a factual inference of inducement depending on the severity of the materiality. I think the only case I wanted to take you to was the ICCI and Royal Hotel case, which gives an indication as to the relevance of such an inference when the actual underwriter has given evidence. Because it's one thing to have an inference if the underwriter doesn't give evidence because he's died or can't be located or is overseas. That's one situation, not the situation here. It's a very different situation where the underwriter gives evidence, prepares 2 witness statements, sets out his evidence, is cross-examined, and then the court's asked to make inferences about what his evidence, info what he would have done when he's never said that himself. So if I could invite you to take out Authorities Bundle 1, please, and turn to tab 8 if you're blessed with tabs.
We are in these bundles.
Right. And it's page 15. This is a decision of Mr. Justice Mance, as he then was. And it was a fire insurance case. I just wanted to take you to page 158, please. And you see, I hope, on the left-hand side, a subheading, inducement. 158, the report. Yep. And if I could just invite you to read that, the bottom of that column, and then the 2/3 of the right-hand column on that page. And I particularly rely on his reference with approval to what Mr. Justice Longmore, as he then was, said in the Mark Rich case, where he draws the distinction that I referred to just now between cases where the underwriter has never called and cases where the actual underwriter is called. If the underwriter is called and doesn't, as it were, come up to proof on inducement, then there's no scope for the insurer inviting the court to fall back on some inference to fill that lacuna in the evidence, because any evidential inference is spent by then. You don't need to infer when you've actually got the evidence of the relevant underwriting. And then we've set out at length in our skeleton the response to this Lim 2 appeal, why the judge was not wrong not to find that the higher premium would have been charged. She was correct to find that a higher premium would not have been charged by reason of any non-disclosed facts. And I think I just wanted to refer, those are set out in our skeleton from paragraph 82 onwards. And I think all I want to do, unless there's anything I need to help with, is to refer you to a couple of passages in the transcripts, because one of the points that was made as well, because of the three inputs, risk management is a sort of non-issue. And that's not quite what the underwriters said. They said, well, risk management is an issue, but the way it's taken into account is by reference to the claims record. Because if you've got a business with a bad risk management approach, that's likely to be reflected in the claims record. So we see that in the supplementary bundle, page 220. Page 220 is a passage from the evidence of Mr. Armstrong, and if we could pick it up on the page 593 of the transcript, on the top right hand box, line 9, I ask, within, for example, in any particular trade, be it waste or builders or whatever, yes, there will be big businesses and small businesses and well-run businesses and less well-run businesses and so on, yes. That would typically be reflected, will it not, in the claims record? Not always, because there's a bit of a luck in the claims record as well. Yes, usually it will give an indication. If the risk is badly run, all other things being equal, it's likely to have a worse claims record than a business that's well run, yes. Part of the premium calculation was based on a claims record, will it not? Yes. And by that means Zurich was charging more for businesses with a bad claims record, yes. So it wouldn't be right to think that Zurich paid no regard to how well or badly a business was run, but that was the way this streamlined underwriting process that it was taken into consideration. And then in the same bundle, could we turn to a passage from the evidence of Mr. Hutchison, please, at 239, that's on 20 pages or so. And it's the bottom right hand corner of the transcript, page 670. Also the line above that, the very bottom of 669, where he says possibly still a bit early. From kind of 13-14 was when we really started to see, pardon the expression, the explosion in fires. We saw lots and lots of fires right across the trade sector. We were beginning to get an understanding that whatever the level of risk management was, with highly flammable waste, you were still going to have fires. And in the market, in the public arena, we could see that they were really, really very regular. In December 2014, yes. You're aware of this as a major headache? Yes. So the Zurich setting its premiums was proceeding on the basis that whatever the level of risk management, there was a very high risk of fires in this industry. then, if I could take you, just remind you of two passages in the judgment, please. Paragraphs 160 and 162. And what I remind you, the judge's findings there was that Zurich was influenced by reason of the fact that it had a long-standing relationship with Niramax, who had paid for insurance since 2006, and that relationship influenced the way it did business, and that it was, as she puts it at the end of 160, prepared to step outside the answer which might be provided by Slavish following a risk matrix in order to maintain a relationship with a long-term client. And that was one of the reasons why she found that there wouldn't have been a refusal to renew. But also, of course, it feeds into the question of, well, was she obviously wrong in not finding that a higher premium would have been charged in circumstances where this was a long-standing client and they were already being charged a 20% increase on the risk in the previous year, without anyone giving any evidence that, yes, they would have charged more than that. So in relation to the question of should the judge have made a finding on that, in my submission, no. Absolutely no. There would have been no evidential basis for her to reach such a finding. And she can't be criticised for not making a finding that was never even argued, let alone evidenced. So that's my submissions in relation to what, was she wrong in not finding that? Should she have found it? So far as the law is concerned, I don't know, the skeleton's full of law, but I'm not sure that they actually arise. I'll deal with anything that would be helpful. We accept that if there is a non-disclosure, which there is a real and substantial and effective cause, even if that only leads to a small increase in premium, that's sufficient to avoid. And that's pre-2015 Act, that was the law, and that's the law that applies in this case. It can give very unfair results, but we accept that's what it was. It's changed now, of course, but that's what it was then. But we don't accept that mere but-for causation achieves that result, because it would lead to the grossly unfair result that the judge identified. It would just give a windfall, particularly where the source of the but-for cause is the fact that a junior underwriter not authorised to write the risk has made a mistake.
When you say it's changed now under the 2015 Act, do you say that because the remedies for innocent misrepresentation are different? Or would you say that because Section 8 in fact uses the language but for as the test of inducement under the new Act?
Yes, what I was referring to was the form of those things, the fact that in the bad old days, if I could put them that way from the insured's point of view, just a small change in premium means no recovery at all, which is now changed with the proportionate remedies. I wasn't addressing the question of whether or not there is a different inducement test under the new Act, because it refers to but for rather than something else. So I don't know if there's anything I can help with on the law, or indeed on anything else.
No, thank you very much indeed, Mr. Elkington. Ms. Reckland.
My Lord, so I have just two very brief points. And the first is just to recognise that the discretion the evidence does establish that there was a discretion which could be applied. It wasn't just a rating exercise that was gone through. And the evidence for that is what my learned friend showed you this morning in the screenshot that went from Miss Jones to Mr. Trinan, asking whether or not he would approve of a 20% uplift. And the submission that arises from that is, if Mr. Trinan had that discretion, then so would Mr. Penny. Indeed, it would be really odd if he didn't have that discretion, given that he was being asked whether or not the risk should be written at all. although he didn't have a discretion to decide, come to a conclusion that yes, it would be written, but it would be written on different terms. So that's the first point. My lords, the second point arises out of the judge's reasons for rejecting permission. It goes back to the findings in paragraphs 211, 212. If the judge's position was truly as is expressed in the judgment she gave for rejecting permission, then it is surprising that she ever went anywhere near the territory of 214. Because all she had to do was to say, I reject the proposition that Mr. Penny would have refused to renew, in which case the claim, if he had refused to renew, the claim would have been dismissed. But I don't accept the proposition that he would renew on different terms. So there are three possibilities. One, Mr. Penny says, I'm not going to renew. Two, Mr. Penny says, I will renew, but on terms. Third, the position that the judge gets to, which he says, yes, he will renew on terms, but actually those terms don't relate to the renewal itself. They relate to corrections and underwriting errors. So the submission that I make is that if the judge really was of a mind, as she says, in the reserved judgment, in the judgments when we sought permission to appeal, it would be very straightforward for her to have said that. In the principal judgment, I accept Mr. Penny, I reject Mr. Penny, would have declined to renew. But I also find that he would have renewed, but on the same terms.
What did she mean by using the words for completeness when introducing paragraph 214?
Well, she must have meant that she was giving some indication of how the premium would change as a result of what she said in 211 and 214 and 212. She must have meant that. There was no reason for her to go anywhere near 214 if her primary conclusion was that he would renew without a change in any terms whatsoever. So that, for completeness, what she was saying was the terms that, in our submission, the terms that he would have imposed would have been by reference to the undercharged premium. That's the additional premium that he would have charged. And it would have been very, very straightforward. Nobody would have been here today if her conclusion had been in the judgment without reference to 214. He wouldn't have charged any higher premium at all. Well, those were the 2 points that I wanted to make.
Thank you very much. Good. Well, thank you both very much indeed. We'll reserve our judgments, which will be circulated for corrections in the usual way, and then we'll invite your submissions, of course, on the form of order. Well, agree an order if possible, written submissions on anything you can't agree, and hand down will be in the now conventional remote manner. Thank you very much indeed.
All right.